for high GC News, Mima Ubibia Aquaba, Hadia latest hot Aramini Bremo. And Sonya subscribe to channel idea, Bomodia say over subscribe. GBA say over click a year the subscribe button. Now wabele notification. We had a video for free be upload when the first person what's Ebeka a year sa video. Afi we are now like video no give us a thumbs up na fi. Share my or for so that when you be here now and some do nara ekoso ewo Ghana memoano afi tente mo imbura ye semwa abeto yepuno so umayiti yes report here about asemi.
Well, I don't see it as an appeal when you are passing a resolution and saying the president should reverse the suspension. I don't see that as an appeal at all. But you know, I haven't read the entire resolution yet, because as I said, tomorrow we are having a press conference, a full press conference on the resolution, and I'm sure we have invited your stations to also come and cover it, so we shall address everything in there. But I am saying that, you see, the GBA is dragging itself into the mud, because if just a week earlier you issue a statement, you didn't see anything wrong with the process, and then you urged all the parties in the process to be fair, to uphold the principles of the Constitution and everything. Then, just a week later, the same organization, the same association shouldn't now come and say that we think that the president is doing something wrong and so he must reverse the suspension and so on. You see, they should have resisted whatever force that was applied on them, so that they will just tell them that no, it wouldn't look good, even in the eye of the public, for us to issue a statement just a week later. Then we are making a complete U-turn. They couldn't do that. They couldn't even do that. And then you are telling me that this association I should protect, I should revere, because I'm a member of it, I should be proud, I shouldn't criticize it, I shouldn't say what exactly the case is. So I'm saying that just a week ago, you issued a statement. Why can't you just hold on to that statement and then maybe you get a larger number of lawyers, or maybe you buy more time, because you urged them, you wanted to see how the process will end, and all of us were happy with that statement, because you didn't support the president, you didn't support the Chief Justice either, and we all believed that was the right thing to do. And then just a week later, and then we heard what went on. I am telling you that we heard what went on over there. Just two people just stampeded the whole executive. There were arguments, there were debates, and then they pushed them to take a vote. You see, and then the GBA succumbed to that, and when they succumbed to that, you are telling me to be proud of the association. So I'm very, very disappointed in the GBA.
Also calling on the President of the Republic of Ghana, John Dramani Mahama, to immediately release the full decision establishing a prima facie case against the Chief Justice, a leadership Gertrude Torkonoo, consistent with established precedent. According to the GBA, this disclosure is necessary to ensure that the process is conducted in accordance with the principles of transparency and fairness. This was contained in a resolution released by the Ghana Bar Association at its recent bar conference in Accra over the weekend. Dennis Pabaywadam is joining me in the studio for a quick detail of this particular statement from the GBA with a number of sub-themes in there, but specific to this conversation is a sub-theme on the suspension of the Chief Justice. What is the GBA saying?
Well, Alfred, it's what has always already been in the media space, except that GBA has come to confirm this. I say so because over the weekend there were reports that the GBA had passed a resolution seeking the president to revoke the suspension of the Chief Justice. That was on Saturday after they had their mid-year conference at the Labadi Hotel. But the GBA itself, we didn't see a statement from them, except the one that they issued on the 24th of April. So 2 days apart, from 24th, then the 26th, there was the passage of the resolution. Now, what is different in this resolution is the fact that, if you recall, the first statement that the GBA issued was the fact that they wanted the process to follow the process to follow what the laid down rules are, and specifically they wanted Article 296 to be followed thoroughly. They didn't give details about that. Now, what we are seeing in this resolution is the fact that the GBA, in asking for the revocation of the suspension of the Chief Justice, is raising issues with Article 296 to say that They are asking the president to do so because the suspension was without the publication of guidelines as enshrined in Article 296, which requires that if a person is going to exercise discretion and that person is a judicial officer, and in this case the president, they contend is not a judicial officer, there has to be some publication of guidelines as to how that discretion was exercised. So to that extent, they want the president to revoke immediately the suspension of the GBA. And for purposes of clarity,
the Chief Justice in this instance.
Come again?
The suspension of the Chief Justice.
Suspension of the Chief Justice. Yeah. So specifically, what they are saying is that the Ghana Bar Association calls for the immediate revocation of the suspension of the Chief Justice, as it considers the suspension to be unconstitutional, considering the fact that the president, who is not a judge or a judicial officer, exercises discretion to suspend the Chief Justice under Article 14610 of the 1992 Constitution in the absence of a published constitutional instrument, statutory instrument, or regulations governing the exercise of his said discretion required by Article 296. The GBA does not end there. It goes on to talk about enactment of regulations, to say that the Ghana Bar Association hereby also calls for the immediate enactment of clear and comprehensive guidelines relating to matters under Article 146 of the 1992 Constitution of the Republic of Ghana to ensure transparency, accountability, fairness in all proceedings involving Superior Court judges, particularly in the context of the impeachment or removal of such officers. Also, you recall that this matter is in court, largely because there are disagreements as to how this procedure should have been executed. While some believe that upon the president's receipt of the petitions, the Chief Justice needs first of all to be notified, her responses taken before the consultation with the Council of State. Others are of the view that it does not matter if the consultation begins and midway the Chief Justice is notified of the petition and then her responses are taken. It's the reason that the old TAFU MP is in court and that matter is still pending. But the Ghana Bar Association is of the view that it's about time there are regulations are enacted so that we have a clear procedure as to how this is supposed to progress. Mind you, even when the Chief Justice asked for the petition and the number of days, she was asking for 7 days. The president gave her 10 days. What essentially means is that with that procedure is unclear how many days one is allowed to use to respond to all those things. So the GBA, even though they've not said that, but knowing what has happened and what's ongoing, you can infer that these are some of the things that they perhaps are looking out for. They are also making a demand for the release of the decision on prima facie case. They say, in addition, the Ghana Bar Association calls upon the President of the Republic of Ghana to immediately release the full decision establishing a prima facie case against the Chief Justice, consistent with established precedent, except they didn't mention the President. This disclosure is necessary to ensure that the process is conducted in accordance with the principles of transparency and fairness. To put this in context, upon consultation with the Council of States, the President and the Council of States, they reach a conclusion that yes, a prima facie case has been established against the Chief Justice, based on which the President exercised a discretion to suspend the Chief Justice. They are saying the reasoning that led to the establishment of such prima facie case should be made public, so that the public get to know how they arrived at that conclusion. They say this is consistent with established precedent. Yes, like I mentioned, they have not mentioned that precedent, but we do know in the case, the earlier petition that was put before the previous president by Professor Kwaku Asare in respect of the same Chief Justice, the presidency issued a statement to explain how they arrived at the decision not to proceed with the matter because there was no case made out of that. That's just one instance. There was also the other issue of ASEPA, which also petitioned for the removal of the former Chief Justice. That the presidency also issued a statement to explain how they arrived at the conclusion that there was no prima facie case established. So the Ghana Bar Association, in this particular regard, even without citing examples, knowing what has happened in the space, we can immediately point out to some of those matters. They also want a denunciation of prejudicial comments. Further, the GBA denounces any and all unsubstantiated political commentary or statements that seek to undermine the authority, independence, and integrity of the judiciary. The association affirms its commitment to safeguarding the sanctity of the judicial process and resolves to take all appropriate legal measures to protect the judiciary from undue interferences and unjustifiable attacks. They now progress to talk about what they say are matters affecting the nation, where they make comments about galamsey and the destruction of the environment and calling for decisive measures to be taken. They also talk about the Boko conflict, commending the agent and genuine mediation efforts. They also call for support for the Asante in his attempt to engage the mediation process, and that comments that incite violence should be avoided altogether. They conclude their statement talking about the unresolved Ablekman North parliamentary elections, and they say that the GBA notes with concern the lack of parliamentary representation for the people of Ablekman North despite their active participation in the December 7 election. They call on the Electoral Commission, the 2024 Election Security Task Force, especially the Ghana Police Service and other relevant authorities to take immediate and necessary steps to resolve the situation by completing the collation process and declaring the results of the parliamentary election so as to uphold the democratic rights of the people of Ablekman North. So this is a statement, this communique dated in Accra on the 26th day of April 2025. 26th is Friday. Saturday.
Oh, Saturday.
Yeah.
Okay, so hold on a bit for me. Martin, private legal practitioner, and this has been following this case quite closely as well. And we also have the leader of the lawyers, president of the Lawyers in Search of Democracy, also joining us. That's Eric Delano Alifo joining us right now. Counsel, good evening. Thank you for joining us here on Hot Edition.
Good evening. Good evening to your listeners, also Mr. Counsel and your colleagues. Good evening to all of you.
And I thank you so much for joining us. I want to find out from you what your thought is on this particular demand by the Bar Association that at least at the minimum, the prima facie case should be made public, the one against the Chief Justice, reason why there was a decision to even suspend her in the first place. And it's consistent with what Professor H. Kwesi had also proposed, that at the least there should be the publication of the reasons behind the suspension of the Chief Justice. What's your thought on this?
Absolutely. The reason is that, we are democracy. And so transparency too is very key in a thriving democracy. You'll find a number of Supreme Court decisions that talk about transparency, probity, accountability, etc. It's even in Paper number 2 versus Attorney General number 2. So the Supreme Court says these are the hallmark, of our democracy. So in other words, these are the pillars that hold our democracy together. So it would be odd to have a decision that remains a secret. And I don't think actually the president intends to do that. Because you remember when the Charlotte Osei matter came, at the end of them, the decision was released. We read it publicly. The procurement breaches, etc. Right? So we knew exactly what caused Charlotte Osei's removal. So in the same vein, and remember, Charlotte Osei was also removed under Article 146. So it's the same thing. It's the same thing, like the same key. About the ball, the chiro, right? Mm-hmm. Yes. So the same thing.
But,
right?
Anyway, so let's do this very quickly. And lawyer, let's get on to the other line as well. Lawyer Christian Hamam Hesse is also joining us as well. Appreciate your time. Thank you for joining us.
Yes, good evening to your listeners, and thanks for having me.
So, Lawyer Alifo, your thoughts on this particular demand by the Bar Association that this prima facie be made public for us all to know?
Yes, well, yes, and I must say that it is not consistent with what Professor Kwesi Prempeh actually wrote. I read his message, and he said that at least at the end of the process, that's what he said. He said that it should be released, whatever proceedings or information about the reasons for why Chief Justice may be dismissed should be released for the knowledge of the general public. That's what he said. And when I listened to Mr. Kwebu, Senior Kwebu, he also alluded to the example in Charlotte Osei's case, but he said that it was released at the end of the matter, at the end of the proceedings, and so we all knew why she was dismissed. At this stage, you know, I must say, right from onset, I have always been saying that the petition should have been released anyway, because I made several arguments and said that my understanding of the proceedings having to be held in camera only refers to the determination of prima facie and the sitting or the hearing of the investigative body or the committee that is inquiring into the matter. That is my understanding. So I thought that the petition should, but of course, and I listened to Senior Kwebu and others right from onset, and they kept saying that they should, once it does to be in camera, everything, and that is the argument I've been hearing everybody say. Everybody thought that, well, the best thing was that nothing was released, the petition was not released, it was only given to Chief Justice and responded. So when I'm hearing this now, and people saying that, well, the proceedings and the determination of prima facie, what went into that should be released at this stage before the case even proceeds, I don't think that is consistent with the position of all the people who are singing this song now. If it were me saying it, yes, then that would have been fine, because right from the onset I said that the petition itself at least should have been released for us to know. But even that, some of the people who are now saying that even the prima facie determination should be made public, who even opposed me when I was saying that the petition should be released, they kept referring me to Agyapong case. So I don't understand. And the GBA, I don't know what they are doing. It's GBA, look, we have to tell them in their faces that they are just behaving like a tool in the hands of NPP. It's as clear as that. You know, we are not going to be shy.
You're not a member of the association. You're a member.
I am a member, but I have to speak the truth. And tomorrow we are having a press conference, and I'm going to speak. I'm going to use stronger words than I'm using now. I'm saying that because we know GBA, less than a week ago, they issued a statement. They've been issuing statements on our behalf all the time. Nobody says anything. And this time around, they issued a statement. And then just about a week later, they went to a mini conference. And then two former deputy attorney generals came to stampede the whole mini conference, pushed them to vote for a resolution. Look, and just about less than 50 lawyers out of about 8,000 lawyers in the country voted 43-4 and said that a resolution should be passed to condemn the president, to ask for the suspension to be reversed. It doesn't make sense. It doesn't make sense. So we have to speak the truth. We have to say it the way it is, because we are never saying, we are always scared, and that is why we are always in a mess, in a big mess. So we don't have to be scared anymore. We have to speak the truth, and the truth is that the same people who said that this has to be held in camera because you don't have to expose. Look, if the information that went into the determination of prima facie case was released, then what? Then they will pick it up in the middle of the proceedings and say that, well, we don't think that this qualifies for the Chief Justice to be suspended, and so he should not be suspended, all of that. So I don't get it. So I'm surprised that some lawyers are agreeing to this. And we know what happened at the mini conference. And I am saying that it was led by two former deputy attorney generals. They stampeded. In fact, when it started, there were even arguments with some of the executives of the GBA. They told them that, no, we had issued a statement already. We didn't see anything wrong that the president had done. But they even said that, well, if they will not pass a resolution to condemn the president, then they must commend him. They must commend him. So GBA has used the MPP elements within the GBA have used the GBA for far too long as a tool to harass NDC regimes.
Well,
and we have sat down and watched them. It is the truth.
So were you there?
Well, anybody can agree with it or not, but that's what I believe, and that's what many people believe. And that is it. And you can't force me for what I believe.
Kazo, yes. I am not forcing you to believe what you want to believe. I mean, that's your opinion, correct? I mean, you hold that view.
Correct. Yes.
But I was asking if you were at this conference on Saturday. Were you there?
I wasn't. But we have a full report of what went into the conference. We know what happened over there. I wasn't there, and I'm telling you that out of about 8,000 lawyers, only about 50 were there. And the matter that is as crucial as this, and so these 50 people will take a decision on behalf of all Ghanaian lawyers by voting, and then the result of the vote was 43-4, and then they want to say that this is what all Ghanaian lawyers, 8,000 lawyers in Ghana are saying. It is not true. That is not what we are saying. And some of us are going to come out tomorrow and say that we do not associate with this resolution. And so if they want to sack us from the GBA, they should sack us from the GBA, because right now I'm saying that they don't want us to have a united front. And we are ready for that, because the GBA is allowing itself to be used by the MPP too much.
Well, hold on a bit for me. Christian Mamhesi is also a colleague counsel of yours as well, a learned colleague of yours as well, an officer of the court, and a member of the Ghana Bar Association as well. Counsel, do you share in this same sentiment by Lawyer Alifo about your association, that you have just been reduced to a political tool against the NDC, essentially?
Thank you for having me, and regards to your listeners. You see, when we have political idiosyncrasies carried around, it is a recipe for disaster, and this should be guarded in a rule-based order. Even when we have our main bar conference, where we are to elect our executives, the statistics will tell you that we have an average of an active membership of 3,000 lawyers nationwide. And even with that, it is not everybody that represents at the Ghana Bar Conference to carry through with elections. And when leadership is elected, are you then to say that because a proportion of it was not at the Bar Conference, the election of the leadership is invalid, even though there was quorum? You see, when we grow into political coloration, it affects the level of intelligentsia. And when a state grows into that level of state, it becomes a problem. Even when objectiveness is the order of the day, it is muddied in a colored milieu, and that milieu becomes a disdain for society to follow. I beg to differ. Even if one holds a different position to the resolution that leadership has come up with at the mid-year review, it should not be carried out by my learned friends in the open and the Ghana Bar Association
when they are doing the wrong thing.
Council, hold on.
Sorry,
yes.
When I hear this,
no, hold on. Yes, hold on, because when he was
speaking, I was very civil.
Hold on.
When he was speaking, I was very civil. I never commented. And
Messi, make your point. Make your point.
Yes,
make your point.
I mean,
yes.
rule of law encourages tolerance. So if tolerance cannot be part of rule of law, then I am sorry. Then I should go offline, because rule of law and civility means that we should encourage tolerance in the body submission of critique. And I'm saying that if even the leadership by the mid-year review had a resolution passed and a certain minority of the association feels displeased with it, you are at liberty to render your displeasure as to the resolution passed. But when now you tout in the glare the very association that you belong, and you say publicly and openly that it is colored in political undertones.
So
it has become the tool of another political. It has become the tool of another political. It has become the tool of another political. Then it becomes a problem, because at the end of the day, we are all members of the association.
Who is creating that problem?
And we stand respectfully. We are speaking to the public, and we as members of the bar, we stand in good standing, and we are officers of the court. We should present ourselves as people,
and we are being dishonest. We are officers of the court, and we are being dishonest.
To take after. It should not be that we are shouting and we are that is not how we are brought up. And that is not the etiquette at the bar. You understand? So if you stand in displeasure with the resolution, you can render your position that even though this is the resolution, in my personal opinion, I disassociate. I don't find it. But to go on to render it as a political tool and to now run down the Ghana Bar Association as the arm of another political tool, I mean, is this the kind of country we want? Is it the rule or that
is the kind of country you are creating? That's the kind of country the GBA is creating.
It becomes problematic. You see, it becomes problematic when we have members
Lawyer, please hold on.
And with the greatest respect, like I said, I had all the tolerance to listen to him. When I never interjected.
Kindly make your point. Yes.
So my point is that save that this is the resolution. Save that this is the resolution of the bar. Whether it is at the bar conference or it is a media review, whether it is 50 lawyers or whatever, there was quorum. Resolution had been passed. The leadership has appended their signature to it. It represents the position of the bar. I, Christian Liberate Mamhesi, I can say that save that the bar has this position. In my private opinion, I differ from whatever is said, and I am allowed within the confines of law and in the confines of rule of law to opine and dissent by my way of personal opinion. It is allowed. But when I now, as a member, I go and attack the position of the bar, then the very bar that we belong to, we are running it in the mud. When this period is over, do we now associate with the highest pinnacle of the bar? No, this is not the bar. This is not the bar of the Francois. This is not the bar of Darocha. This is not the bar of the learned Asante. This is not the bar that we find. This should be the bar when the position is given. If you find a dissenting opinion which is different from it, state it as it is. Don't run the very bar that you belong to down. And tomorrow you associate yourself with the same bar for the same public to see you in the high light of it. This is not how we run in the high saddle. This is not it. Now, given the opinion or the resolution given by the bar.
Okay, why you round up for me, please?
I have observed that it is trying to express an appeal to the president in the light of Article 296 of his discretion.
No, at what point exactly, and this is where I come in, what point exactly does this appeal by the GBA find any covering in the dictates of 296 that the president should make public the prima facie against the Chief Justice, reason why she's been suspended? Where exactly in 296?
You see, Article 296, as for the past week, I have submitted on your platform. Article 296 has a checkered procedure, and the learned retired jurist, in the sense of Justice Dapaah in the Frank Chum case, opined in his leading judgment that Article 296 is Article 146 is fraught with procedural lapses. And that procedural lapses, he called upon the Constitutional Review Committee to come up with lasting procedures to deal with this particular proceeding.
Until then, the president cannot exercise discretion?
Now, in the current position as we have it, the president has not erred, and that has not been the position of anybody. In fact, no lawyer has said that the president... No lawyer has said that the president has erred. But the point is, given that there is no clear procedure, and given that there is a call on transparency devoid of political idiosyncrasy, the Ghana Bar Association is calling for a greater transparency and a greater exercise of discretionary power under Article 296.
If you say there's no clear procedure, exactly what do you mean? The
Edutum case even did what we call judicial filling in the gap by saying that the second level that deals with prima facie when it comes to the removal of the Chief Justice was not made known in the provision, and by that Supreme Court provision, the Edutum case indicated that a prima facie case ought to be established. Is the prima facie case in Article 2, is it in the Constitution as far as that particular provision is concerned? No. But by judicial filling in the gap, as Lord Denyon had indicated in other common law cases, that was done in the Dutum case. And it has become part of our body judicial decisions.
Okay.
So, a clearer call on the position does not mean that the president has acted unconstitutional, but it is a call on a clearer and a certainty in that area of law by way of judicial certainty and clarity. But it is not that the president has erred on point of constitutional proceedings.
Okay, so just your final thoughts on this. Exactly where is the point of departure from what lawyer Christian Mamhesi has clearly elucidated? Specific reason aligning with the GBA's position, and he says this, in his view, the wording of this statement is more of an appeal to the president and not an instruction per se.
Well, I don't see it as an appeal when you are passing a resolution and saying the president should reverse the suspension. I don't see that as an appeal at all. But I haven't read the entire resolution yet because, as I said, tomorrow we are having a press conference, a full press conference on the resolution, and I'm sure we have invited your stations to also come and cover it. So we shall address everything in there. But I am saying that, you see, the GBA is dragging itself into the mud because if just a week earlier, you issue a statement, you didn't see anything wrong with the process, and then you urged all the parties in the process to be fair, to uphold the principles of the Constitution and everything. Then, just a week later, the same organization, the same association shouldn't now come and say that we think that the president is doing something wrong and so he must reverse the suspension and so on. You see, they should have resisted whatever force that was applied on them, so that they will just tell them that no, it wouldn't look good, even in the eye of the public, for us to issue a statement just a week later. Then we are making a complete U-turn. They couldn't do that. They couldn't even do that. And then you are telling me that this association I should protect, I should revere, because I'm a member of it, I should be proud, I shouldn't criticize it, I shouldn't say what exactly the case is. So I'm saying that just a week ago, you issued a statement. Why can't you just hold on to that statement and then maybe you get a larger number of lawyers, or maybe you buy more time because you urged them, you wanted to see how the process will end, and all of us were happy with that statement because you didn't support the president, you didn't support the Chief Justice either, and we all believed that was the right thing to do. And then just a week later, and then we heard what went on. I am telling you that we heard what went on over there. Just two people just stampeded the whole executive. There were arguments, there were debates, and then they pushed them to take a vote. You see, and then the GBA succumbed to that, and when they succumbed to that, you are telling me to be proud of the association. So I'm very, very disappointed in the GBA.
Well, we'll wait for that position of your press conference, but really,
Yes.
that in a sense, for him, to the extent that the GBA had already stated their position on this, indicating that they were going to watch the process closely and ensure that it indeed follows the dictates of Article 296, and then 2 days later they issued this resolution in the words of Council. Yes, quickly.
Be mindful that the only opposition we were getting to this whole process was coming from NPP anyway, and so when the GBA came and GBA took the middle line, and then they went for a conference and NPP elements again went there. So nobody can tell us that we shouldn't think that the GBA is partisan. It is partisan,
well,
clearly partisan. And we shall say so.
So just for the optics, he says from the optics point of view, it doesn't look too good for the image of the GBA.
No, I mean, when we have a lawyer speaking like this, I mean, it's problematic. I mean, an officer of the court scandalizing its own association and saying the GBA has become partisan. I mean, it is problematic. And for me, in the modern society, where these are the things Socrates and Aristotle spoke about, we cannot have such a statement like this. I mean, the very pluralistic.
You have just.
This same association, no, if you depart from it, come out with your objective argumentation. But when you scandalize it and you reduce it into such aprophy, it becomes a problem. Now, the GBA had maintained that due diligence should be followed. Now, and in its further position by the media review, it had maintained this resolution. That is an appeal. I mean, it is a progression. So, I mean, I am not saying that he cannot differ, because we are all human beings and we can differ from
in thought and in position.
Of the majority.
Right on. And Christian Helsemam, appreciate your thoughts on this. Let's see how the coming days will look like. Right on. Thank you so much. He's a private legal practitioner and then also a constitutional lawyer. Eric Delano Lifo is also a private legal practitioner. He is the president of the Lawyers in Search of Democracy, also joining us with his thoughts on this.
Yo, if you winning and someone about better, you so Mikau says so. We now subscribe to channel idea, but more than say over subscribe. Now, what like video, give us a thumbs up. Now, share my waffle frost. So now when you be here now, and somewhere also, Ghana memoir. Also, bit me otchere wondering a fire and some way you know comment box in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.